want to welcome to the stage my friend and was never my fellow colleague at the Department of Energy, but he and I both had the same job there at times in our lives as General Counsel of the U.S. Department of Energy, John Brightbill. John was nominated by the President last year, confirmed by the Senate, and appointed to the position of General Counsel at the U.S. Department of Energy, and has a really broad and interesting portfolio there, and works with a number of really great people, both in the General Counsel's office and at the department. But John, let's just get right to it.
All right. Thank you for having me. Thank you to the Bipartisan Policy Center for this. Looking forward to it.
Thank you very much for being here. So you've had senior administration roles. You were at the Department of Justice during the first Trump administration, and now you're at the General Counsel of the Department of Energy here during the second Trump term. Based on what of your experience at DOJ and at DOE, what do you see as the kind of the biggest federal permitting obstacles to new infrastructure?
Well, I think a lot of people have spoken about it today, but the two words are first of all, certainty, but then where does certainty and really uncertainty come from? It's litigation. When people talk about permit reform, really what that means to most people who are looking to finance and build big new infrastructure projects is the uncertainty that comes from permitting, and most especially from NEPA, to a lesser extent from a scope perspective, the Endangered Species Act, 401 uncertainty, and why are we concerned about all of those things? Ultimately, it's the litigation risk, and it is the litigation risk that drives so much of the dysfunction in the broader permitting apparatus, including the hundreds and hundreds of pages and the many, many, many years of studies and analysis that is done and that has had to have been done in this country, really over the last 50 years to try to get big new infrastructure built.
So you've mentioned to me before that you really think of permit reform as being litigation reform or reform of the judicial review process. I mean, how is it that what is it that you think needs to be done in order to successfully address that?
Well, I think we've had some really positive progress here in the last 6-7 years. I think it started during the end of the last Trump administration. I was part of a very small cadre of political appointees who worked to try to pull together the regulatory package that ultimately became the CEQ NEPA reform regulations of 2020. And a big part of what we were trying to do in those regulatory reforms was not only just to address, people talked about page limits, time limits, okay? None of that matters. None of that matters if it doesn't come with litigation reform, because the reason why EISs and studies became so long, and the reason why things took so much time, was that the need and the perception that you needed to address every argument, close off every mouse hole, bar every door in your environmental studies, and that took years and years and years, or otherwise a court of law would come along at some point, enter an injunction, send you back to the drawing board, and your project and your millions and millions or even billions of dollars, it goes down the drain. So one of the things that we really looked to do in the context of those regulations was to create various processes, define very clearly the scope of the project, is defining what it is, and that you needed to meet the project's purpose and need in order to have something qualify as needing an environmental study. We talked in those regulations about exhaustion, about creating notice and comment opportunities, but ultimately trying to make people come forth and put their evidence on the table, give the project sponsors and the agencies the opportunity to hear the arguments that are being presented, respond to them. So we were very fortunate, though, because even though we successfully defended those regulations and those reforms against all comers up until the change of administrations. Ultimately, the Biden administration came in, took those down. They went another direction. But we were very fortunate. Actually, Representative Graves, who was on the table, was part of the group that kind of spearheaded taking the CEQ regulatory reform regulations and actually seen a lot of those, not all of it, but a lot of really good stuff that was pulled out and developed there into what was the Builder Act portion of the Inflation Reduction Act. And so those reforms, dealing with categorical exclusions, dealing with the limits ultimately of how broad your environmental review needs to be. A lot of those things ended up getting incorporated into the Builder Act. And then on the back of that, even more importantly, we had the Supreme Court come down with the 7 counties decision. Not because the 7 counties decision broke new ground. It affirmatively did not. The public citizens case, what we would refer to at DOJ as the Mexican trucks case, because that was the facts. That was really the groundbreaking case, but that was back in 2004, and in district courts of appeal, they just didn't apply it, quite frankly, on a very sparing basis. So 7 counties came in and was a very, very, very decisive opinion by Justice Kavanaugh that the public citizen decision means what it said, and being a lot more express about how it should be applied going forward. And so I think we've actually had, through the existing legislation, through the Supreme Court precedents, I think we've actually moved the needle a lot. There's more, of course, that can be done, and I'm been very pleased to hear about the amount of discussion about bipartisan legislation to try to advance permitting certainty even further.
Well, so John, a couple of things that you touched on there. First of all, 7 counties. Can you talk a little bit about how you and your colleagues in the administration are implementing that decision or are thinking about it, applying it in the work that you're doing?
Sure. So 7 counties has a number of important features, but one of the most important aspects of it is making clear the causation standard, which actually did first appear in Public Citizen, but that the causation standard as a kind of determination of how far your environmental impact statement and environmental analysis has to go, that should be reflected in judicial review, and in particular, the discussion about environmental effects that are too distant in either geographic or temporal scope are beyond of what needs to be considered in a NEPA analysis. And I think that was implicit, and certainly I was involved in litigation in cases where it was argued that was already in Public Citizen, but having Justice Kavanaugh draft that opinion and make that statement so clearly, I think was very important. Again, the Supreme Court had already written on numerous occasions that NEPA is a procedural statute. It's not supposed to be substantive. District courts, the Ninth Circuit was not listening to that. So having 7 counties come in, make a very clear statement that this is a procedural statute, and therefore the remedies in the event of a failure under NEPA is not I think at all really after 7 counties, but certainly it would take us a very, very special case, is not an injunction, but go back, look at your NEPA failings and gather that additional information and correct your lack of information. And so I think those 2 aspects of it are very important. And so the President's Council on Environmental Quality has obviously put out new guidelines. I think the other thing that was very important was President Trump came in, and within a month of being in office, he issued an executive order that repealed CEQ's delegation to promulgate regulations. The reason why that was important is that by doing that, President Trump essentially hit the reset button on NEPA. That from 1969 through the first set of regulations that came during the Carter administration in the late 70s, and then on up through, you've had this immense development of Byzantine standards that courts were constantly wrapping the knuckles of project sponsors and the government against in terms of reviewing their NEPA analyses that were based off of interpretations of these regulations. And so one of the things that President Trump did was, we're going to wipe all of that clean, and we're going to go back to the statute. Because the statute actually isn't very long and isn't very complicated to implement. The original statute, I mean, I mean, you can fit the whole thing on a couple pieces of toilet paper. It's so short, right? After the Builder Act, there is more statutory framework that had imported some of our regulations. But by wiping all of that clean and now promulgating guidelines, we allow federal agencies to do what the statute requires, and that's all from a judicial review perspective that courts can and should hold them to. And then we have guidelines and guidance on how federal agencies, project sponsors, and the like can look to implement NEPA on more complicated cases.
So you've talked a little bit about what the administration has done, both the current administration as well as what the things that you worked on at the end of the first Trump administration. And I know it's not, you're not here to tell Congress what it ought to do. But are there things? What would be on your list of things that Congress could do that you think would actually, and that in some respects only Congress could do, that you think would help reduce the time, the cost, the burden, the uncertainty of permitting?
Yeah, well, this is, John Brightbill's personal views. This is not the administration's views. We have legislative folks who will engage with the members of Congress on the various bills, but just some of the things from my own personal experience that I think are important features of what should be considered is, to be a broken record on this, judicial review and looking at how it's done. Because if you go back, and again, NEPA, super short statute on a couple pieces of toilet paper, one of the things that you do not see is any provisions in there for judicial review. There are a lot of scholars and people who debate, was NEPA something that anyone was supposed to sue over at all? Or was this a purely aspirational statute that encouraged federal agencies as a matter of policy to consult with the president, to consult with CEQ, and to consider these things? But there is no judicial review section, or hasn't been, or historically was not, for NEPA. Contrast that then with the major environmental statutes that came after that. The Clean Water Act, the Clean Air Act, the Endangered Species Act, RCRA, CERCRA. So you go through all of these statutes, and you find that Congress is thinking about the fact that we are creating actually rights that are going to impact the public, and we're going to create provisions for judicial review, and then we're going to have ways to organize that and make sure that it's conducted in a predictable and fashion. You don't have any of that in NEPA. It's a straight APA backdoor. And what that has meant is you have district courts around the country, very idiosyncratic in their applications.
APA Administrative Procedure Act.
APA Administrative Procedure Act violations. And in particular, in the early days, this was the 1970s. So for those of you who are not scholars of administrative law and the history, the 1970s, prior to the Supreme Court's Vermont Yankee era, was a time of the courts making up all kinds of processes in administrative law and rights that were not on the face of statutes and that were more than what Congress itself had articulated. So you have a statute around which there have been hundreds and even thousands of cases that has no guiding framework as to how to conduct judicial review. And so, some of the things that I think could be helpful are figure out once and for all where venue belongs on these things. Clarifying burdens of proof. I think one of the things that would be super important is, and some of these provisions, is making sure that if and where it's appropriate to give public comment on certain actions that require that kind of input, you have an exhaustion requirement and a prudential standing requirement. So if you want to sue on something and it's important enough to you, come to the public comment process and make your comment. And then after you've made that comment, if it isn't accommodated, then after you've exhausted your administrative remedies before the agency, then you can bring a lawsuit in federal court. That's very, very, very standard operating procedure across a whole host of other federal statutes, but it's not in NEPA. Why is it not in NEPA? Because was anybody supposed to sue under this statute in the first place? Again, question of debate.
So the topic of regulatory certainty is really important out there. it's always been important, but particularly for anybody thinking about their federal permits, their authorizations, as well as trying to deploy at-risk capital. What's your view about things that the administration can do to help promote regulatory certainty?
Well, I think one of the things that we are doing is we are trying to create a set of more basic, consistent guidelines that tightly follow the statute, and then we've kind of wiped away some of the extra complications that create extra opportunities for footfall. I think another thing that many of the agencies are working on, and this again follows from the legislation that Representative Graves was such a big part of in the Builder Act, but really starting to expand the use of categorical exclusions, which were not in the original statute. They were a function of the regulations, but now they've been incorporated in. And so wanting to try to develop categorical exclusions for different situations that recognize that there are certain things that happen time and time again that do not have a significant environmental impact and do not require years of study and hundreds of pages of analysis. But also, I think the other important thing when you look at the history of NEPA and how we got to where we are is it's considered to many scholars in the area the very, very first of the major environmental statutes that now drive the United States regime, passed in 1969. But since that time, we, as I've said, have so many of these other statutes that have made great, wonderful impacts on cleaning up the environment in the United States and helping to bring us, the cleanest air, cleanest water in the world. Now, as part of that, we have many other federal agencies whose job, responsibilities, statutes, regulations are addressing environmental issues. And so, and they have primary jurisdiction of figuring out how to solve those problems, how to permit those problems, and how to supervise those problems. The idea that we have now NEPA sweeping in, putting the Department of Energy that may, for example, be extending a loan to someone who wants to build a nuclear power plant, doing NEPA on the environmental effects of our loan, when you're going to have federal agency after federal agency and state entity looking at this project when it actually comes to fruition, looking at the environmental effects, dealing with those environmental effects, right? It just doesn't make any sense. And in fact, that's one of the things that the Builder Act legislation created an exemption from the definition of major federal action to deal with, and we're very pleased with that, of course. But those are some of the things that we're looking to execute on to try to create a more streamlined process and therefore more predictability for those who want to build infrastructure, and particularly energy infrastructure in the United States today.
John, I realized that I started this off earlier today by saying it was important to really stay on time, and I know we're at the end of our time, but I'm going to use up 30 more, I'm going to give 30 more seconds to ask you a question about the Clean Water Act. How important it is that, how would you say, what needs to be done, or what is your view with respect to things that need to be done as to the Clean Water Act in order to improve permitting and regulatory certainty?
Well, I know a number of people have made reference to this, but Clean Water Act Section 401, which involves states in reflecting on water quality issues related to federal actions, right, is a provision that has not always been used and is often not being used as a either in the first instance related to water quality, and even when it is related to water quality has been used not as a, hey, we will want to take a good faith look at the water quality issues here and try to mitigate them, because ultimately you've got all kinds of permitting standards and you have all kinds of other laws that are in effect and that will impact and ensure water quality. It's being used as a veto, a holdup. And so I think that we've seen that really at a bipartisan level across various states. And so I know that there's been a lot of discussion during this fine event from a number of people who have identified that as as an issue, and I think that's one that those who favor real concrete permitting reform should take a very hard look at.
And that only Congress, in the end, can address.
And really only Congress can address, in part because of various Supreme Court and other appellate decisions that have construed the existing language in a pretty firm way.